2021, new laws went into effect that changed the landscape of Texas sexual harassment law. The first change I'll be discussing concerns the extension of the window of time that a claimant has to file a charge of discrimination. A charge of discrimination is an official document recognized by the EEOC as well as the Texas Workforce Commission, in which a claimant asserts factual details in support of their claims of discrimination or harassment. Prior to the changes in the law, employees had only 180 days from the date of the alleged harassment to file a charge of discrimination with the Texas Workforce Commission or the EEOC. They now have 300 days to file a charge of discrimination with the appropriate government agency. This new 300-day deadline mirrors the deadline found in the federal law equivalent to Texas's sexual harassment statute. The new law also now applies to all employers with one or more employees. Texas has expanded the definition of employer so that it applies to all employers, not just those who employ 15 or more people. This change has a significant impact in that it applies to a large number of smaller Texas employers who previously were not susceptible to potential legal action under this law. This new law also dictates that supervisors and managers can be individually and personally sued in a sexual harassment lawsuit under Texas law. Prior to the 2021 changes, only the employer could be named as a defendant in a sexual harassment lawsuit. Employers can act to shield themselves from liability under these new laws by having procedures and processes in place to ensure that immediate and appropriate corrective action is taken in response to any complaint of sexual harassment. Another way that employers can be proactive is by verifying that their sexual harassment policies are consistent with the new Texas law. Taking action to prevent sexual harassment and the proper handling of sexual harassment claims can save employers from having to spend time and money on litigation that can be costly and time-consuming. It can also protect an employer's managers and supervisors from being personally and individually sued for allegations of sexual harassment.